Welcome back to SCOTUS Oral Arguments and Opinions. Yesterday we discussed Hensley v. Fluor Corporation. Today we discuss a case that reads like a Hollywood script.
Picture this. A woman violates her supervised release, disappears without a trace, and evades capture for nearly 5 years. When she's finally caught, the government says time stood still while she was on the run. Now, we've all seen those fugitive movies. The Fugitive, The Shawshank Redemption, even Dog the Bounty Hunter. There's this popular notion that when you're running from the law, the clock stops ticking on your sentence. But here's the twist. What if that's not actually written in any law?
That's exactly what Rico v. United States entails. Isabel Rico thought her 42-month supervised release term expired while she remained missing. The government says not so fast. Because she became a fugitive, she actually owes over 60 months, making crimes she committed years later into fresh violations.
So imagine you're told you have a 3-year probation sentence. You disappear for 5 years, get caught, and suddenly the government says, surprise, you still owe us time plus interest. That's not a Hollywood plot. That's happening in federal courtrooms right now.
And here's what makes this Supreme Court worthy. There's no law that actually says fugitive time doesn't count. Courts just decided it shouldn't, based on this idea that fugitives shouldn't benefit from their own wrongdoing. But can judges extend criminal sentences that Congress never authorized?
The stakes here extend far beyond RICO. This affects thousands of people on federal supervised release and gets to the heart of whether courts can enhance criminal punishments without explicit congressional authorization.
So let's start with the question the Supreme Court will decide: whether the fugitive-tolling doctrine applies in the context of supervised release.
Now, that sounds simple, but let me read you the key statutory text that's driving this entire dispute. This comes from Section 3624, subsection E, of the United States Code, which governs when supervised release terms start and stop. This is the provision RICO says should end the case.
Here it is. A term of supervised release does not run during any period in which the person is imprisoned in connection with a conviction for a federal, state, or local crime unless the imprisonment is for a period of less than 30 consecutive days.
Wait, so you're telling me that Congress wrote exactly one tolling rule for supervised release when someone is imprisoned for more than 30 days and said nothing about fugitives?
That's exactly Rico's point. She argues this is what lawyers call expressio unius est exclusio alterius. When Congress includes one thing, it excludes others. If Congress wanted fugitive tolling, why didn't they write it into the statute like they did for imprisonment?
And here's what makes this even more interesting. The term supervised release itself is key. For our listeners who might not be familiar, supervised release is what happens after you get out of federal prison. You're not on parole. That's different. You're subject to conditions like drug testing, reporting to a probation officer, not committing new crimes.
Right? And the whole point is rehabilitation and community reintegration. But if courts can indefinitely extend these terms whenever someone disappears, that undermines the entire purpose Congress had in mind.
Let's tell Isabel Rico's story because it shows how this doctrine works in practice and why it's so controversial.
Isabel Rico pleaded guilty to a drug trafficking offense in 2010. She got 84 months in prison followed by 4 years of supervised release. After she was released in 2017, she violated some drug-related conditions, so her supervised release got revoked. The court then gave her a fresh start, 2 more months in prison, followed by a new 42-month supervised release term beginning in December 2017. This new term was scheduled to expire in June 2021.
Here's where things went sideways. In May 2018, Rico failed a drug test, missed appointments with her probation officer, and moved to Northern California without telling anyone. Now, this wasn't some dramatic fugitive chase. She and her mother simply relocated without notifying the court. But that simple move without notification triggered what the government calls abscondment. The probation office filed a violation petition and issued a bench warrant. Rico remained at large for nearly 5 years until January 2023. During this period, Rico committed some state law offenses. In January 2021, still before her scheduled June 2021 expiration date, She was arrested for evading police and driving without a license. Then in January 2022, after her supervised release should have ended, she was caught with fentanyl for sale. And here's the million-dollar question. Is that January 2022 drug offense a supervised release violation or not? Rico says no, because her 42-month term expired in June 2021. The government says yes, because the fugitive-tolling doctrine paused her sentence clock in May 2018.
The practical consequences are huge. If the 2022 offense isn't a violation, Rico faces an 8 to 14-month sentencing range. If it is a violation, she faces 33 to 36 months. The district court sided with the government and sentenced Rico to 16 months. The Ninth Circuit affirmed, but notably said they were bound by circuit precedent. That suggests some judges might have doubts about this doctrine, but felt constrained by existing decisions. And that's created a circuit split. Different federal courts are handling fugitive tolling differently, which is exactly the kind of inconsistency that brings cases to the Supreme Court. The Supreme Court granted certiorari to resolve this split and clarify whether fugitive tolling applies to supervised release.
Let's break down how each side makes their case. Rico offers 3 main arguments, and they're all pretty powerful. First, she says there's simply no textual basis for fugitive tolling in the Sentencing Reform Act. Rico quotes this fundamental principle. It is essential that Congress should define the offenses to be tried and apportion the punishments to be inflicted. That goes back to 1798. For this argument, I find compelling Rico's argument that Congress knew exactly how to authorize tolling when it wanted to. The statute includes one specific tolling rule for imprisonment, but says nothing about fugitives. When Congress uses such specificity in one area but not another, courts shouldn't judicially engraft that language into other areas.
Rico's second argument focuses on statutory history, and it's fascinating. In 1976, Congress explicitly authorized fugitive tolling for the old parole system. The Parole Commission even wrote regulations implementing it in 1983. But when Congress abolished parole in 1984 and created supervised release, they deliberately left fugitive tolling behind. So Rico argues, Congress knew how to include fugitive tolling. They had done it before, but they chose not to do it for supervised release. That's a pretty strong signal of legislative intent.
The third argument gets into what lawyers call common law incorporation. The government argues that fugitive tolling is such an established common law principle that Congress must have intended to include it silently. Rico responds, "Show me the cases." And not to get too far ahead, but that's one area where I'm curious to see how things play out at oral argument. Rico points out that the government identifies no case that has ever applied its purported common law rule extending absconders' release conditions past the scheduled expiration date. Literally, none. If there's no tradition, there's nothing to incorporate.
The government counters with 3 arguments of their own. First, they focus on what supervision actually means under the statute. The government argues that the law requires defendants to be supervised during their term. They say you can't get credit toward your supervised release term for periods when you're not actually being supervised. It's like saying you can't count time toward a work requirement if you don't show up to work.
That's actually pretty intuitive. The government distinguishes between being subject to conditions, which continues during abscondment, and receiving actual supervision, which stops. They argue Rico remained bound by her conditions, but wasn't earning credit toward completing her term.
The government's second argument is about common law tradition. They cite cases going back over a century showing that fugitives don't get credit for time they spend evading justice. They argue this principle has deep historical roots in both English and American law.
The government also invokes a canon of statutory interpretation that says Congress doesn't displace common law principles without a clear statement. Since the supervised release statute is silent on fugitive tolling, they argue the background common law applies.
Their third argument is pure policy. Allowing fugitives to earn credit while absconding creates unjustified windfalls and undermines the whole supervised release system. Why would anyone comply with supervision if they could just disappear and run down the clock?
For our listeners, let's clarify a few terms that keep coming up. Tolling usually means pausing or stopping a time period. But what the government calls fugitive tolling here doesn't actually pause Rico's supervised release. It extends it indefinitely.
Right, and supervised release is different from parole. Parole was the old system where prisoners got early release with conditions. Supervised release happens after you serve your full sentence. It's additional supervision on top of your prison time. Grade A violations versus Grade C violations matter for sentencing. More serious violations like felonies are Grade A and carry much higher punishment ranges. Rico's January 2022 drug offense was classified as Grade A, which is why her potential sentence more than doubled.
Looking ahead to oral arguments on November 3rd, I'll be watching for several key dynamics. First, how do the justices react to Rico's textual argument? If Congress included one specific tolling rule but omitted fugitive tolling, do the justices see that as dispositive? Or do they think there's room for judicial gap filling? I'm particularly curious about Justice Barrett and Justice Kavanaugh, who both have extensive criminal law backgrounds. This case really tests the tension between textualist interpretation and practical law enforcement needs.
The historical argument could be crucial too. When the government talks about century-old precedents, will the justices buy that those cases established a tradition relevant to modern supervised release? Or will they side with Rico that no such tradition actually exists? Watch for questions about practical implementation. If Rico wins, does that create problems for supervised release enforcement? If the government wins, does that give courts too much power to extend sentences beyond what Congress authorized?
The policy arguments might reveal the justices' broader philosophies about criminal justice. Justices who favor rehabilitation might be skeptical of indefinite sentence extensions. Justices focused on public safety might worry about creating fugitive incentives. I'll also be listening for questions about the rule of lenity, the principle that ambiguous criminal statutes should be interpreted in favor of defendants. If the supervised release statute is genuinely ambiguous about fugitive tolling, that principle might tip the scales toward Rico.
And don't overlook separation of powers concerns. This case really asks whether courts can enhance criminal punishments that Congress hasn't explicitly authorized. That could resonate with justices across the ideological spectrum who care about constitutional boundaries.
So, why does Rico versus United States matter? On one level, it affects thousands of people currently on federal supervised release who need to know whether their sentences can be indefinitely extended if they abscond. But the broader implications are huge. This case tests fundamental principles about judicial power in criminal law. Can courts fill gaps in criminal statutes when they think Congress left something out? Or must criminal punishments be explicitly authorized by the legislature?
The answer could influence how courts interpret criminal statutes across the board. If the court says judges can apply background common law principles to enhance sentences, that's a big win for prosecutorial power. If they say criminal punishments must be textually grounded, that strengthens defendant protections.
This case also highlights the human costs of technical legal doctrines. Rico's case turned on whether a judicial doctrine that exists nowhere in the statute books could more than double her sentence. That's the kind of real-world impact that makes abstract legal principles matter.
For practitioners, this decision will be essential for advising clients about supervised release compliance and violation consequences. Defense attorneys need to know whether their clients face 42-month terms or potentially indefinite extensions.
We'll definitely be covering the oral arguments live and breaking down the eventual decision when it comes out, likely by spring 2026. This is exactly the kind of case where oral argument tone and questioning can give us crucial insights into how the justices are thinking.
Thanks for joining us for this deep dive into Rico versus United States. It's a perfect example of how seemingly technical criminal procedure questions can reveal fundamental tensions about democratic governance and judicial power. As always, if you found this helpful, please rate and share the podcast. And if you're a criminal defense attorney, prosecutor, or probation officer, we'd love to hear your thoughts on how fugitive tolling plays out in practice.
Thanks for listening to SCOTUS Oral Arguments and Opinions. If you enjoyed the content, please follow, rate, and share the podcast. In the next episode, we discuss Haynes Celestial Group Incoser versus Palmquist, a case that attempts to answer 1. Whether a district court's final judgment as to completely diverse parties must be vacated when an appellate court later determines that it erred by dismissing a non-diverse party at the time of removal, and 2. Whether a plaintiff may defeat diversity jurisdiction after removal by amending the complaint to add factual allegations that state a colorable claim against a non-diverse party when the complaint at the time of removal did not state such a claim.
Talk to you soon.